Once the property is transferred to the beneficiary, do the property taxes get reassessed? The answer to this question is yes. When property transfers out of your name or out of the name of a trust into your beneficiary's name, then the property does get reassessed for determining what the property taxes will be. And as you can imagine, if you're here in Florida, property has risen substantially over the last several years. So oftentimes the newly assessed value is higher. So sort of depending on the circumstances, this could mean a significant hike or a significant increase in property taxes. I do have a lot of clients that talk to me about this very issue. So I'm glad this came up in the comments. Because a lot of times what I see in my practice is I have a couple who bought a condo or bought a home years and years and years ago. And as an example, maybe they bought it for around $200,000 or $250,000, and now it could be upwards of $1 million. Sometimes even closer to $2 million, depending on where it's located and how the property has increased. So even if this property is owned free and clear, there's an issue with them giving it to their children or passing it down to their beneficiaries through a trust or through a ladybird deed, because although the children can inherit the property free and clear, they may not be able to pay the increased property taxes. So I will often have my clients ask me, is there any way to pass my homestead exemption or our homestead exemption, our property taxes onto our children? Can we do this? Is there a way that they can inherit our taxes? And I wish that were a thing. I wish we could do that, sort of pass that, keep them going on the same homestead exemption. That would be great. But I guess it's probably looked at along the lines of, well, you get the step up in basis. So if you inherit property through a trust, through a ladybird deed, or however, when you inherit property, you do get a step up in basis for capital gains tax purposes, meaning if you turn around and sell the property, usually within 6 months to a year, you get to calculate your gain based off of the value that the property was when you inherited it, against what you sell it for, versus needing to use whatever your parents or whatever the purchase price was. So there's a much smaller gain there on average. So typically you don't have to be subject to capital gains taxes. Also, unless we're talking about very, very large estates that might have already used up their entire amount of the gift and estate taxation limit, which is currently $13.6 million for individuals and $27.2 million for couples. So unless we're talking about a very, very large estate, oftentimes too, there's no inheritance tax to be worried about with these houses either when they're inherited. So you do get a break there with the capital gains and with the inheritance, but unfortunately there isn't a break with the property taxes. Now, of course, whoever inherits the property can always apply for homestead once they inherit it and once they're on the title, and that can help, but it definitely doesn't get you back to where the property taxes were before you inherited it. So the only sort of piece of advice I can offer here that could potentially be a workaround in your specific situation, but only if it works, is I do sometimes see this in my practice where an adult child or the beneficiary or beneficiaries are actually living in the home. So it technically is their homestead. They're adults, but they're living with their parents. And that's the house they plan on staying in and want to continue living in that home, but they're not currently on the title because it's their parents' home. So in these scenarios, I actually have had clients add their beneficiary to the title as a joint tenant with rights of survivorship. So that's very important. It has to be done that way. It cannot be tenants in common, and it cannot be silent, because if it's silent, and it means tenants in common. But if you add your beneficiary to the deed as a joint tenant with rights of survivorship, and that beneficiary is actually qualified to have that property be their homestead, then they can, of course, also apply for homestead in the property and share that homestead with you at the same time. And that may be a better route to go, because it could save on whatever the property taxes would be whenever they end up inheriting the property. It's not something I typically recommend for inheritance, only in very limited circumstances, but sometimes it does work, and that's also why it's good to look at the overall picture of what's trying to be accomplished here. And a lot of times it does depend on, is the beneficiary planning on making this home, or continuing, I should say, to live in the home for the rest of their life, making this home their homestead, for the rest of their life, and not just selling the home. So this is why it's important to bring up these types of things when you do talk to your estate planning attorney, to find out what the best route is for you, because we have lots of different planning tools, and it's really important to know the full picture so you can get the best advice. All right, so I hope this helps and answers the question regarding the property tax increase when a beneficiary inherits. If you have any other questions like this, or any questions related to estate planning, asset protection, elder law, and you are in Florida, please contact our office, atCause Law Office. The link is in my bio.